All right, listen up. Employers, severance agreements prevent lawsuits. I'm Matthew Brown, and I'm a labor and employment attorney. So, one of the biggest risks I see clients take is terminating employees without a severance agreement. What many employers don't understand is that a severance agreement is not about generosity, it's about risk management. When drafted correctly, severance agreements can reduce legal exposure, secure releases of claims, protect confidential business information, and control how the separation occurs. Most employment claims don't come from bad intent. They come from poorly handled exits. You wouldn't believe how many lawsuits I've handled over the years for unpaid wages, discrimination, or retaliation, all because a termination was handled poorly or a measly severance package was offered and ultimately rejected. I'm currently handling a situation where a client of mine offered a few $1,000s in severance to an employee who had worked for over 15 years just because they didn't think he was entitled to more. Of course, that employee sought legal counsel and is now threatening to file a disability discrimination lawsuit. However, a more meaningful severance package could have avoided the situation. In addition, a well-structured severance agreement gives both sides clarity while giving employers certainty and finality. This is exactly why we advise employers to have a severance strategy before termination decisions are made. So if you're an employer navigating terminations, consult with your employment counsel and HR team before you make a costly mistake. And remember, follow me for more labor and employment insights.